One of the common questions that we get as real estate attorneys is how can we pass our property onto our children without going through probate or with the least hassle as possible. What we typically recommend is, and what we tell people is, each situation is a case-by-case basis because each family's situation is different. However, one thing I would want to warn you against is the most logical things would seem to be just to make your child a joint owner with you on a piece of property, when in fact that normally is one of the worst things that you can do. But for instance, let's say that you have a daughter and you put her on the title with you jointly. Say your spouse passes away and you put your daughter on the property with you and she owns it jointly with you. First of all, there's no guarantee that you're going to outlive your daughter. So the transfer to joint tenancy with your daughter may really serve no purpose at all. Secondly, there are no guarantees that your daughter would not encounter credit problems, marital problems, things such as that, and you could find yourself in the middle of a bankruptcy or a divorce with your property involved in that, and that's not something that anyone wants to see happen. So we advise against, except in the rarest of circumstances, to obtain property jointly with your children. You can do a trust that will avoid probate. You can reserve a life estate in the property that will avoid probate, or you can also do what's called a beneficiary's deed that will avoid probate. All of those options are much better alternatives than making your children a joint owner on a piece of property. Another problem that we see sometimes if parents are just insistent upon putting their children's names on the property, they will sometimes do that and the children may be underage or minors. Under Arkansas law, you must be 18 in order to have the capacity to sign a contract, mortgage, or other legal document. If you put your children on title with you and they are under 18 and you go to sell the property, you have to have a formal legal guardianship set up for the children for them to be able to sell the property. What that does is add unnecessary expense to the sale of your property. So number one, it's not a good idea to add children to your property as joint owners, but certainly you don't want to add underage children. As far as real estate laws are concerned, those are very much state-by-state laws. One law that is somewhat unique to the state of Arkansas is that if you are married, your spouse must always sign the deed and must always sign the mortgage to the piece of property. The purpose of this is the wife, in signing the deed, waives her dower interest in the husband's property, and the husband, by signing the deed, waives the courtesy interest in the wife's property. There is no way around this. When you get ready to sell a piece of property and you're married, both spouses are going to have to sign. It's like I said, Arkansas has laws that are unique to its real estate, just like other states' laws are unique to that particular state. That's one law that seems to surprise people. So if you're buying or selling property in Arkansas, you need to realize that there's going to be a certain amount of involvement with your spouse when it comes to signing the documents at closing. We've already mentioned that Arkansas has unique laws when it comes to who must sign a real estate contract if you're married. Another law that's somewhat unique to Arkansas has to do with what's called adverse possession, or it can also be called boundary line by acquiescence. And basically what that means is if someone puts a fence on your property or a row of shrubs or something that clearly marks the boundary, and that boundary stays that way for 7 years or more, then that line of shrubs or that fence line is in all likelihood going to be the line between the two parties. So it's possible that you could possibly lose or gain property depending upon the location of a fence or location of shrubs. And that's something you might want to be aware of when you're looking to buy a piece of property or when you're looking to sell a piece of property, is that the fence, if it's not on the line, if it's been there for more than 7 years, more than likely it's going to be the line with very few exceptions. One final difference that Arkansas law has, and maybe one of the more significant differences, is our usury law. Many times someone will want to sell a piece of property and they'll be willing to carry the paper, we like to say, or to finance the purchase price for the buyer. In that situation, Arkansas's usury law limits the amount of interest that you can charge between two individuals. As at this time, the rate is a little over 5%, 5.5%, but that changes daily. So anytime that you are financing a piece of property for someone, or someone is financing a piece of property for you, before you agree to do that, you need to inquire as to what the maximum rate of interest you can charge between two individuals is in Arkansas. Let me emphasize to you, it's not the prime rate, it's not 5 points above prime. Arkansas is different than that, and you need to check that out at the time you do your transaction. Many of the properties in Arkansas involve what we would call manufactured homes or mobile homes, which have a title to the property apart from the real estate. In years past, as long as your mobile home or manufactured home was permanently affixed to the real estate, it was regarded to be as part of the real estate, and it was just transferred with the warranty deed to the property. However, recent banking regulations have made it so that you actually have to have the title to the mobile home or the manufactured home at the time you purchase the mobile home or manufactured home. So it's very important that if that is what you are purchasing, that you make sure that you have the title. It's also important that if you are selling a mobile home or manufactured home, that you locate the title. If you cannot do that, there are several procedures that you can go through. First of all, you can go through a procedure to obtain a lost title through the Department of Finance and Administration. There's also a procedure that you can go through the court system with the state of Arkansas to get an order directing that a title be issued to your particular mobile home or manufactured home. Then there's also a procedure that you can go through to get a bonded title on the mobile home or manufactured home also. What I would suggest is that if you are purchasing or selling a piece of property that involves a mobile home or a manufactured home, that you make sure that your realtor is advised of that, or that whoever you are buying or selling from or to is advised of that, and you get the title situation checked out before you get to the date of closing. Because the problem is very solvable, but lots of times there can be delays if you don't think about it before you get to closing. If you should have any questions on real estate issues, please feel free to call me at 870-425-2126 or visit our website, which is johnsonsandersmorgan.com.